was decided by all 17-member full court, where the Viaries of National Reconciliation Ordinance 2007 was struck down, was under question and was struck down. Then, sir, next very important case was Nadeem Ahmed versus Federation of Pakistan. In this case, insertion of Article 175A was challenged, and therefore the bench which was formed was of full court. All 17 judges, Chief Justice and all 16 judges sat in this case, where the Viaries of certain provisions of the 18th Amendment was there. And in that case, what happened was that matter was partly decided and partly sent to the Parliament for adding 2 more judges to the Supreme Court under the Article 175A, and it was done under the 13th Amendment, 19th Amendment. And therefore, citation is, sir, citation is PLD 2010, Supreme Court 1165. The next, again, very important case is that of District Bar Association Rawalpindi versus Federation of Pakistan. PLD 2015, Supreme Court 401. In this case, Viaries of 18th and 21st constitutional amendments were challenged, and the 17-member bench, the full court, sat on that and ultimately decided the petition against the objection, because it said that since by amendment, 19th Amendment, they have already added 2 judges under Article 175A, therefore that matter is rest. So now this is not a question of judicial independence. So therefore that was allowed. And the other matter in this was that of military courts for 2 years, introduced under the 21st Amendment, in which by 11-6 our petition was dismissed. But one thing very remarkable about is that actually the judgment, which is the main judgment on merits, I will be relying on that judgment, because there at least 14 judges out of 17 agreed that these are the basic features of the Constitution.
Salient features की बात की,
salient feature की बात की, मगर वो अमेंडमेंट को अप्रूव कर दिया प्लूरिटी जजमेंट के अंदर भी और वैसे भी
वो कर दिया, लेकिन उसमें जहां तक defining the basic features of the Constitution, उस पर 14 judges पर,
which include the independence of judiciary as well.
Independence of judiciary and separation of powers, the democratic system, all that. That was at least by 14 judges.
के अगेंस्ट तो होल्ड तो नहीं किया उसको उन्होंने
जी,
बेसिक फीचर के अगेंस्ट होल्ड तो नहीं किया वो 17 जजेस ने
किया, मैं समझता हूँ किया। उसकी वजह यह है कि उसमें तकरीबन जो 6 डिसेंटिंग जजेस थे जो उन्होंने हमारे हक में फैसला किया था, उसमें 5 जज ने तो क्लियरली ये कहा, एक जज ने वेंट इनटू ऑल टुगेदर डिफरेंट टेंजेंट, जस्टिस खोसा, so they did not consider that. But out of those so-called majority, 8 judges agreed with that there is basic features of the Constitution, and anything against it can be struck down. They made an exception of the 21st Amendment by saying that since it has a sunset clause, that is, the military courts were allowed only for 2 years.
and again
Therefore,
2 years
they said we are ready to condone it. Otherwise, substantively they said that it should be struck down. Then, sir, next very important case in this regard is
ये जो salient feature की बात हुई थी 17 जजेस ने, now it will be considered a judgment of 17 members.
this is 17 by
salient feature की बात उसमें हुई थी
जी, उसमें
अगर जो मैं कहने वाला हूँ कुछ, अगर कोई उससे छोटा बेंच होगा تو ان سیلینٹ فیچر کو چینج کر سکیں گے یا نہیں کر سکیں گے؟ جو بات 17 نے کہی ہے کیا وہ 13 یا 15 یا 16 کر سکیں گے، یعنی اس کے اگینسٹ جا سکیں گے یا نہیں جا سکیں گے؟
میں نہیں سمجھتا
اور اگر اس سے زیادہ ہو تو جا سکتا 17 سے اگر زیادہ ہو
دیر ہیز ٹو بی، یہ 17 سے زیادہ، کیونکہ بے شک 14 نے یہ بات کہی ہے لیکن وہ ججمنٹ تو
17 کی، وہ 17 کی تصور ہو.
نیڈ مور دین 17 ٹو ڈو
کیا
دیٹ.
خوش نہیں ہوں گے کہ وہ برقرار رہے اور 17 سے ایک چھوٹا بینچ ہو؟
The next judgment I'll be relying on is Justice Qadi Faiz Saab versus President of Pakistan. This is PLD 2021 Supreme Court 1. In this case, there were objections on some of the learned judges. So therefore, the full court was agreed upon, they agreed that there should be full court. Court of 10 judges, because rest of them had either recused themselves, so therefore only these 10 judges for the available full court, they sat and decided this. Similarly, afterward then its review petition was heard by again the 10-member bench. This is Justice Qadi Faiz versus President of Pakistan, PLD 2022 Supreme Court 199, in which
دوبارہ بتائیں
جی سر
PLD
199
PLD سپریم کورٹ
and sir
199 سال کے.
sir about reconstitution there is another judgment.
بہتر ہوتا حامد صاحب اب ہمیں یہ لسٹ پرووائڈ کر دیتے
ویسے by tomorrow I'll have this list provided here. جی سر اس میں ایک اسٹیج پر یہ ہوا تھا کانسٹیٹیوشنل بینچ کا پرابلم معاملہ آیا تھا کیونکہ 6 ججز کے سامنے ریویو پٹیشن لگی تھی and we objected to that it has to be heard by 10 judges, a bench of 10 judges at least. In that case, it was decided, yes, the same number of judges will hear the review petition and the same judges. But in the meantime, one of the learned judges who formed the majority in that case, Justice Faisal Arab, I think he had retired, and in his place, Justice Aminuddin Khan was made a member of that bench. So therefore, that was for all intents and purposes a full court that heard. Then Raja Amir versus Federation of Pakistan.
کر رہے ہیں بتا دیں پورے کتنے اور باقی ہیں 2 چیز باقی.
Raja Amir versus Federation of Pakistan. The Supreme Court Practice and Procedure Act was.
اس کا سائٹیشن بتا دیجیے.
I'm just going to conclude. 1 or 2 and what.
عامر کا سائٹیشن بتا دیجیے.
جی سر اس کی سائٹیشن ہے PLJ ہے PLJ 2024 Supreme Court 114. So what I'll say, very correctly pointed out the lady Justice, that formation of full court for hearing important constitutional cases is a matter of precedent and convention in Pakistan. If your lordship kindly see the record of the last 60 years, 70 years from 1955 to 2025, all important constitutional cases, including the cases pertaining to the constitutional amendment, have been heard by the full court.
Sir, don't you think all these referral cases are distinguishable? Because during all these decisions, there was no Practice and Procedure Act, nor there was any 26th Amendment. And second, are we all bound by the law and the Constitution or not?
Sir, the difference is that in these cases, whether the Practice and Procedure Act had come or not come, there was an authority who could form a bench, full court. So therefore, it didn't matter who had the authority. The fact remains, the bottom line is that full court heard that case.
In all these cases, Chief Justice was the authority. And he constituted the bench on administrative side, and on judicial side, all the sitting judges heard the matter. But now we are having some constraints. CJP is there, but the constitutional bench is also there. There are two committees dealing with the affairs of fixation of the matters.
So that
We are again at point zero.
I follow your lordship.
Moving around a roundabout. You're not leading us to any path.
Sir, what I am submitting here, that whoever may have the authority, but the bottom line is all cases of this importance are heard by full court.
Third question, whether any application was filed before the committee of the Constitution bench to fix the matter before a larger bench or the full court of the Constitution bench?
We are challenging the very formation of that committee.
I don't think so.
Because we think that Article 191A is ultra vires the Constitution.
Yes. You've concluded on this application.
हामिद साहब, एक मेरा ख्याल है, एक मैं जो समझ रही हूँ अभी तक,
जी, जी।
एंड दैट इज कि आपके ख्याल में फुल कोर्ट इसलिए भी जरूरी है कि जो अमेंडमेंट्स हो चुके हैं अकॉर्डिंग टू यू, वो जो सेलियंट फीचर्स है कॉन्स्टिट्यूशन के, उसी वो नहीं रहे अभी अपनी जगह पर बहुत सारे. तो यू मीन कि वो कॉन्स्टिट्यूशन फुल कोर्ट की हो जाए सो दैट द मैटर इज डिसाइडेड वंस फॉर ऑल.
As for all, by consensus of this court.
By consensus of
What
this
I am
court.
saying is that-
Bypassing the
आपका अच्छा किया था मेरिट से, क्या होगा वो मेरिट पे आज मेरिट अभी
की भी कोई स्टे होनी चाहिए. हर दफा सुप्रीम कोर्ट उनका जजमेंट अंडू कर देता है. ये माजी की बातें हैं, ये सब जजमेंट में लिखी हुई
ये रिसेंट है 2012 ये 11
इवन के एक जजमेंट हमारे पास था पेशावर हाई कोर्ट का, दैट वाज ऑथर्ड बाय मी एंड द 3-member बेंच वाज हियरिंग दिस मैटर, जस्टिस मुनीर आई एंड जस्टिस अथर. दैट वाज डिसेंटेड बाय मिस्टर अथर ऑन दिस ग्राउंड कि एवरी जज, एवरी मेंबर हैज अ राइट टू से.
अब आप एक क्वेश्चन और ले लीजिए कि आप कहते हैं कि एग्जेक्टिव की आजाद पढ़ आप बार को किस पलड़े में डालते हैं, एग्जेक्टिव में ये जुडिशरी, इसमें नॉन जुडिशरी किधर पाएंगे ना, वो दे ओनली रिप्रेजेंट बार, देयर आर 3 फैक्टर्स, लेकिन एग्जेक्टिव को तो नहीं करते. ठीक, इसमें पहले तीनों थे, उसमें लॉ मिनिस्टर भी थे, अटॉर्नी जनरल भी थे, बात के नुमाइंदे भी थे, लेकिन मेजॉरिटी वाज रिटेन्ड बाय द सुप्रीम कोर्ट, बाय द जजेस, बट देयर वाज सेपरेट कमेटी ऑफ पार्लियामेंट वाले, वो एक अलग थी. अब वो मर्ज हो गया. अब बात के नुमाइंदे अगर तो सॉल्व करें तो शायद पहले, फिर इसमें ये तो उसके मेरिट्स की बात. इसके
आप जरा हिस्ट्री में जा रहे, थोड़ा सा 18th में जा रहे, थोड़ा सा 18th अमेंडमेंट से पहले भी बता दें कि क्या सिस्टम हुआ करता. 18 से पहले,
18 से पहले तो सिर्फ यही होता था कि अपॉइंटमेंट ऑफ हाई कोर्ट जज वाज इन कंसल्टेशन विद द चीफ जस्टिस ऑफ दैट हाई कोर्ट एंड द चीफ जस्टिस ऑफ पाकिस्तान. उसको इंटरप्रेट किया हुआ है जजेस केस 1996 एंड सब्सिक्वेंटली असद अली केस.
given to the chief justice. Primacy.
After that, judgment's primacy. At that time, it was entirely in the hands of the judiciary. Appointments and from appointment of judges, they have the final say, meaning by a majority. What has been transformed? At firstly, under the 26th Amendment, that majority is gone, which majority at one place was made part the direction. No doubt, at that time, when that direction was given in 2010, already the 18th Amendment had been passed. It could have been those learned judges could have said, what can we do? Now this is what the Parliament has done. But no, they said, we have to ensure, we have to guard against the independence of judiciary, against any violation of the independence of judiciary. Therefore, we give a direction. And then we will see if they follow the direction, whether it was now in accordance with the basic structure or not. And they finally said it.
यहाँ पे एक सवाल कर रहा हूँ, डायरेक्शन किस बारे में? ऑलरेडी एक कॉन्स्टिट्यूशनल अमेंडमेंट हो चुकी है, उसको अमेंड किया, यानी उस अमेंडमेंट को मानते हुए दूसरे अमेंडमेंट के लिए डायरेक्शन. हम सिंपल ये कह रहे हैं कि एक अमेंडमेंट हो चुकी है, क्या आप उसको मान रहे हैं या नहीं मान रहे हैं? असल बात इतनी है,
नहीं मानी गई ना,
मानी गई
नहीं, जो डायरेक्शन दिया ना 2010 वाली डायरेक्शन है, मैं आपको
उस 18th अमेंडमेंट को फर्दर अमेंड किया गया था. इट वाज पार्ट ऑफ द कॉन्स्टिट्यूशन, इट वाज फर्दर अमेंडेड.
and the court direction was given. Such a direction can even be given at this time also. There is a precedent.
So,
No doubt
it is
about
a
it.
constitutional committee constituted under Article 191A presently.
That is why that committee initially decided that it should be a full court. We should first decide the validity of the 18th of 26th Amendment, because this is where
the question for the constituting the full court, whether after 26th Amendment, the earlier committee constituted for the regular bench under the practice and procedure can decide the fixation of cases of the constitutional nature before the full court or not. This is the moot point which you have to argue and satisfy us on this point.
Certainly.
This is in fact the case.
certainly, because that's where the conflict comes. You see that we are challenging the very basic structure.
Mr. Shahid in petition has also he has raised the same question that the committee has decided to fix these cases.
वो
before
लास्ट
the
में
full
लेंगे
court.
आपके पहले ये
नहीं, वो आपका पॉइंट वही है. This
जी,
is in
बिल्कुल वही
fact
point.
the entire controversy is roaming around the. जी ठीक है, ठीक. That is why we are asking to
ऑब्जेक्शंस हैं आपके सुने.
senior advocate to address on this point.
Yes, certainly, sir. Like for this, because everything you see, if for the time being, as it was a controversy when we filed these petitions before this honorable court against the basics, against the 26th Amendment, we do not want that under 26th Amendment should be came into effect, because that would create the confusion which exists at this present time. It appears. For the time being, this honorable court has to consider that all that has passed between the 21st of October till today actually has ceased to exist. You have to see that we are virtually on the 26th or 27th of October 2024, because we are challenging that act of the parliament which took place at that point in time. So what is subsequently, some of the part had been come into effect, some have not come into effect. One of the reasons we have been repeatedly saying, making petitions, I have been filing petitions, one was dismissed in their special court cases, where I said that first please decide 26th Amendment case. And then the rest of things should happen.
यही
That's what-
प्रॉब्लम यही है. अभी हम इस मौके पर इस स्टेज पर भी नहीं पहुंचे कि किसने सुनना है इसको. ये चलता रहेगा. पॉसिबल है अगले एक महीना हम इसी बात पर सुनते रहे. जैसे लॉयर्स पीछे भी 40 डेट ऑफ हियरिंग दी है, फुल स्ट्रेंथ पे सुना है. अब इस पॉइंट पर ही जब एग्री नहीं हो रहे कि किसने सुनना है, ये आप 10 दिन बहस करेंगे भी यार है तो हेयर यू.
जी सर.
तो इसलिए बाकी सारा काम रोक के वो नहीं, इस पॉइंट पर एग्री फर्स्ट डे होते आप कहते हैं आप सुन सकते हैं. आज भी आप कहिए कि जी आप नहीं सुन सकते,
तो डे वन से हम कह रहे हैं.
यही कह रहे हैं. लेकिन अंडर व्हाट प्रोविजन ऑफ द कॉन्स्टिट्यूशन
सर देखिए, ये
आप
जो
कहते हैं कि उसको इग्नोर करके 26 से पहले चले जाए, ये तो हमारे बस में तो नहीं है.
I think the difference between substantive provisions and procedural provisions we have, which is something I noted in the dissent in the reserve seat case, nothing is barring a judicial order. Just to be clear, nothing bars a judicial order that a full court needs to hear the matter or a bench needs to hear the matter. The judicial order takes place, the process continues. After the order is made, then there is the process that implements the order. So the focus really, as I see it, again, my question is that when you ask for a full court, where is the bar under the 26th Amendment to form a full court? And if where is the bar and who is to form that? And is that the request, the direction to form it, not something that is done in ordinary cases as well. So why not in this case?
No doubt. There is no bar. Let me give a...
In fact, at the instance of the bar, we often say there is a request for a larger bench, there is the request for a different bench, and we put the file forward. At that time, we don't question the process that will take place. We simply issue a directive that do it, and then the process takes place.
So there's a lot of precedent on that. I'll come to that.
आप प्लीज जरा
Full courts were formed.
इसको एड्रेस कर दीजिए ना इन इश्यूज को तो
उसी पर मैं
अगर आप आर्टिकल
क्वेश्चन
यहाँ तो
रिपीटेडली वी आर आस्किंग क्वेश्चन टू यू प्लीज एड्रेस दिस पॉइंट
जी।
बताइए इसके ऊपर
खान साहब एक मुश्किल आसान करते हैं। खान साहब एक मुश्किल आपकी आसान करते हैं। बेंच के मेंबर्स ने जितने सवाल पूछे हैं उसका क्रक्स लेने के लिए अकॉर्डिंग टू माय परसेप्शन आप खुद भी क्लियर नहीं है। जरा आप आइए सीएमए की प्रेयर क्लास पे आइए, सीएमए की प्रेयर क्लास जरा गौर से पढ़ें। आपने ये नहीं कहा कि ये बेंच एक ऑर्डर पास करे और ये बेंच लार्जर बेंच को कॉन्स्टिट्यूट करे। आप प्रेयर पढ़ें जरा प्लीज।
It is most respectfully and most humbly submitted that this honorable court may graciously refer this present petition as well as corrected petitions for the constitution of a bench consisting of full court,
बस यहाँ रुक जाएं।
which includes
किसको
all.
आपने ये नहीं कहा कि ये बेंच किसको रेफर करे, किसको रेफर करे ये बेंच?
Naturally to the Chief Justice.
नहीं तो वो तो आपसे मैंने कहा ना चीफ जस्टिस तो अब नहीं है मास्टर ऑफ रोस्टर तो कमेटी है एट द बेस्ट द मैटर विल बी रेफर्ड टू द कमेटी but
This is what I meant. That at that time, the authority which could constitute full court, उसके पास भेज दिया
बेटा
जाए.
दोनों चीजें अब अलग हो गई। एक तो रेगुलर बेंचेस की कमेटी है, द चीफ जस्टिस कैन नॉट कॉन्स्टिट्यूट द बेंचेस without placing it before the committee members by majority of जो भी होगा. Similarly, the senior member of the constitutional bench cannot constitute any committee by his own, any bench by his own. He himself or he can't do this. He has to refer this matter to the committee. And again, the same committee for the constitutional bench will decide the constitution of benches for hearing of cases. So both committees are at par presently, one for the constitution and one for the regular.
दो कमेटीज है, किस में जाएगी? दो कमेटी, एक कॉन्स्टिट्यूशन के तहत कमेटी बनी है, एक एक्ट के तहत बनी है। तो आप ये भी हमें बताएं।
मेरी गुजारिश ये है कि वो कॉन्सिक्वेंस है 26th अमेंडमेंट का, विच इज अंडर चैलेंज बिफोर द ऑनरेबल कोर्ट। उस पर अच्छा फिलहाल आपने
एक बात जरा सुन लें। इससे पहले कई अमेंडमेंट्स कॉन्स्टिट्यूशन में थी या ओरिजिनल कॉन्स्टिट्यूशन था, जब तक वो कॉन्स्टिट्यूशन का हिस्सा था उस पर अमल होता रहा। मिसाल के तौर 52B हिस्सा था आइन का, बहुत से लोग इसको नहीं मानते थे लेकिन इम्प्लीमेंट होता जा रहा था। जिस दिन वो खत्म हुआ उसके बाद इम्प्लीमेंट नहीं हो रहा। सवाल ये नहीं है कि ये अमेंडमेंट अच्छे हैं या बुरे हैं, ये तो हम बाद में डिसाइड करेंगे कि ठीक है या नहीं है, कॉन्स्टिट्यूशनल है या अनकॉन्स्टिट्यूशनल। लेकिन जब तक ये खत्म नहीं हुए, ये तो इसमें मौजूद है। अगर आप आर्टिकल 191A3 पढ़ लें, देयर इज अ बार, आप पढ़ लें या फिर हमें बताएं, हम इससे क्या देखें, आप हमें इससे निकाल लें।
हम तो कहते हैं 91A को फिलहाल आप नजरअंदाज करें क्योंकि ये तो प्रोडक्ट है
एनी प्रोविजन ऑफ द कॉन्स्टिट्यूशन उसको रिडंडेंट कर सकते हैं। हम किसी प्रोविजन को रिडंडेंट कर सकते हैं,
रिडंडेंट ऐसे कर सकते हैं। एट द एंड ऑफ द डे you can
we can strike it down. We can, yes, of course, but so far it is part of the constitution.
ये हामिद
For the time being, it is under question.
ये बेंच जिसने बनाया था, द अथॉरिटी विच कॉन्स्टिट्यूटेड दिस बेंच, क्या उनके पास आपकी तरफ से कोई रिक्वेस्ट गई थी कि लार्जर बेंच बनाया जाए? एंड दैट एप्लीकेशन रिक्वेस्ट हैज बीन टर्न डाउन, कोई रीजंस दिए गए हों उसके?
देखिए, हम तो इसकी फॉर्मेशन को चैलेंज कर रहे हैं जी। हमारे नजदीक 191A के तहत जो इख्तियारात दिए गए हैं बेंचेस फॉर्मेशन के, दे आर कॉन्सिक्वेंस ऑफ 26th अमेंडमेंट। We think this amendment has virtually destroyed the independence of judiciary and separation of powers, and therefore we are not going into acts which are consequential of 26th amendment.
You're right, but during that process of challenging whether it is not in a field, it is in a field, 191A. So we cannot wriggle out of it. It is not, maybe you are challenging it and you don't accept this. This is what you are challenging before this court. But the fact remains, it is in the statute book or not. It is a part of constitution or not.
It is very much, unless this honorable court gives.
If we pass any judicial order, perhaps, as you argued that this court can pass the judicial order, the judicial order should be within the jurisdiction or beyond jurisdiction. If we have jurisdiction under Article 191A to constitute the full court, please show us from the text of Article 191A. So this is the question of jurisdiction also. If we pass any judicial order, then we have to see what jurisdiction vested in it. Whether we can do this under Article 187.
Yes, under Article 187. Very much.
ये बताइए ना आप इसके
तो
ऊपर.
देखिए बात ये है कि वो 26th अमेंडमेंट या उसके कॉन्सिक्वेंसेस तो हम चैलेंज कर रहे हैं, हम उसमें फिलहाल जाना नहीं चाहते.
We are not taking to there. We are asking for the bench only. We are not asking you to argue on the merits of the case.
We are only saying that on the judicial side, kindly consider this as important for saving the basic features that a full court should sit and decide. For example, the same situation arose back in 1997 when a judicial order was passed that the court should hear the cases under which challenge was made to the appointment of the then Chief Justice of Pakistan. And a bench was formed. Bench was directed to be made under Justice Siddiqui, who was head of that bench. The senior Justice Siddiqui, or the senior puisne judge at that time, Justice Ajmal Mian, recused from there. But nobody questioned the judicial powers of a bench of the Supreme Court to direct formation of the full court. So that is a precedent. Otherwise, when this matter was before them, it was challenged even that Chief Justice has not formed this bench. How come you have formed the bench? The answer came that on the judicial side it could always be done. But if it has to be done on the administrative side, it has to be Chief Justice.
अगर इस तरह समझ लें खान साहब की जुडिशल साइड आपकी बात मान लेते हैं, फर्ज करें अगर आपकी बात मानते हुए हम ऑर्डर कर देते हैं कि तमाम जजेस जितने भी सुप्रीम कोर्ट के हैं, दे शैल बी मेंबर ऑफ द कॉन्स्टिट्यूशन बेंच, वुड यू बी सेटिस्फाइड?
Member of the Constitutional Bench.
सारे तमाम जितने जजेस हैं सुप्रीम कोर्ट के, will you be satisfied or not?
नहीं, इसमें मेरी गुजारिश होगी be satisfied if all 16 judges.
16 को ले लेते हैं. अगर हम ऑर्डर कर देते हैं कि ये 16 जजेस कॉन्स्टिट्यूशन बेंच का हिस्सा बने, फिर आप सेटिस्फाई होंगे?
हिस्सा बना कॉन्स्टिट्यूशन बेंच का जो तस्वर है वो आपने 26वीं तरमीम के तहत दिया है.
हमने नहीं किया, पार्लियामेंट नहीं किया, हम पे ना डालें. पार्लियामेंट
उसी को तो हम चैलेंज कर रहे हैं.
ठीक है, हो सकता है आप सक्सीड कर जाए, हो सकता है आप सक्सीड कर जाए या ना कर जाए.
एक मिनट के लिए आप 191A को भूल जाइए, और द रीजन दैट वो तो अंडर चैलेंज है ना सर. तो आप ये देखिए, हम वहां खड़े हैं जहां
अगर 191A को भूल जाए तो फिर तो कॉन्स्टिट्यूशन बेंच का तस्वूर ही खत्म हो गया. फिर बाय वी आर सिटिंग हियर,
कॉन्स्टिट्यूशन बेंच इंटरनल बेंच
खत्म हो गया. उसका नो कॉन्स्टिट्यूशन बेंच.
खान साहब सुनिए, देन देयर इज नो सुप्रीम कोर्ट इन द कंट्री टुडे. There is no Supreme Court.
That's what we are saying. The Supreme Court is there.
तो फिर अगर आप 199 को अगर आप 191A को नहीं मानते हैं, फिर तो ये बेंच खत्म हो गया. बेंच क्या? आप कह रहे हैं उसको हम भूल लेते हैं. चले हम भूल लेते हैं, आपकी बात मानते हैं, हम भूल जाते हैं, एक साइड पे रख लेते हैं, फिर तो ये बेंच खत्म हो गया.
नहीं होता. It's a bench of the Supreme Court.
This is the creation of Article 191A1 and A4.
Even today, Supreme Court is under Article 191.
फिर आपको पार्लियामेंट को अप्रोच करना पड़ेगा कि एक फुल बेंच बना के एक
कोर्ट बना है. पहले तो सुप्रीम कोर्ट
पैदा हो सकती है, बट थिंग्स हैव टू बी रिजॉल्व्ड जुडिशली. और इसको जुडिशली, वरना अगर हम इससे बाहर निकल गए तो फिर हमारी जुडिशरी बिकम्स टोटली मीनिंगलेस. तो हु विल सपोर्ट? बात यहाँ पर जो हम कर रहे हैं, ये 26th अमेंडमेंट इज एन अटैक ऑन द इंडिपेंडेंस ऑफ जुडिशरी. दैट्स व्हाट माय आर्गुमेंट. इसको प्रोटेक्ट करना, इस कोर्ट को और इसकी इंडिपेंडेंस को, ये सुप्रीम कोर्ट का अपना काम है. और इसलिए हमारी सबमिशन है, आप कॉन्स्टिट्यूशन बेंच नहीं, आप 8 मेंबर बेंच है इस ऑनरेबल कोर्ट का, और आपने हमारी सबमिशन को एक्सेप्ट करते हुए 16 मेंबर बेंच यानी फुल कोर्ट दैट एग्जिस्टेड द टाइम ऑफ पासिंग 26th अमेंडमेंट, उसका जुडिशियल ऑर्डर पास करना है।
Ignoring
इस बेंच को चीफ जस्टिस ने या वो जो प्रैक्टिस एंड प्रोसीजर कमेटी ने नहीं बनाया,
नहीं बनाया।
ये बेंच उसके तहत बना ही नहीं है। तो अगर आप उसको नहीं मानते हैं फिर तो इस बेंच का वजूद ही खत्म हो गया,
मैं
फिर हम ऑर्डर कर ही नहीं सकते।
हम तो आपके सामने जुडिशियल ऑर्डर सीख रहे हैं।
देखिए ना,
ये बेंच नहीं कर
हम भी
सकेगा।
191 को इग्नोर करें कि वो जुरिस्डिक्शन जो अंडर द कॉन्स्टिट्यूशन सिर्फ कॉन्स्टिट्यूशनल बेंच को है, हम बाकी जजेस को वो मतलब कन्फर करें बाय ऑर्डर ऑफ दिस कोर्ट to hear these petitions.
तो 191A जो है वो तो फिर infructuous हो गया ना, it has become redundant, and before hearing you it amounts to making it redundant unless you argue the whole case at the relevant time, and we will reach to the conclusion whether it is against the basic structure or what are the defects in the amendment. That would be a different story. But right now you know that you are very senior counsel. Article 5 of the Constitution, loyalty to the state is the basic duty of every citizen. Obedience to the Constitution and law is the inviolable obligation of every citizen, wherever he may be, and of every other person for the time being within Pakistan.
Yes.
So 191A is a part of Constitution presently, unless it is treated otherwise or struck down at the final stage of the case. But right now it is the part of the Constitution. You say that ignore it and make the full court. How within that jurisdiction we can do this? I am asking this for last many
सर मेरी गुजारिश है कि मैं बारहा अर्ज ये कर रहा हूँ कि आपको 1 मिनट के लिए ये तस्वर करना पड़ेगा कि आजकल 26वीं तरमीम पास हुई, अब इस पर कोई एक्ट ऑन नहीं हुआ। तो अब देखना ये है कि ये जो 26वीं तरमीम है क्या ये आइन के बेसिक स्ट्रक्चर के मुताबिक है कि नहीं।
That will be seen at the relevant time when you will argue the case on merit.
इसलिए
But right now this is question of bench. You are asking us to do something which can be do under the Constitution. Please satisfy on this point.
सर वो हम उस पर सेकंड स्टेज पे आएंगे। मैंने पहले ही कहा ये जो कुछ भी मैं सबमिट कर रहा हूँ ये फुल कोर्ट फॉर्मेशन के हवाले से है, क्योंकि इम्पोर्टेंस ऑफ द सब्जेक्ट बिफोर योर लॉर्डशिप इज सच इम्पोर्टेंट वन दैट ओनली हाफ ऑफ दैट फुल कोर्ट इज एट प्रेजेंट बिफोर अस। वी आर ओनली सीकिंग कि प्लीज आल्सो include the other learned 8 judges who were judges of this honorable court at the time when 26th amendment was passed. This is nutshell of my submission. और इसके लिए आई एम ट्राइंग टू टेक प्रेसिडेंट। आपके पाकिस्तान के प्रेसिडेंट क्या है
बताइए।
मैं आपको ब्रीफली सारे प्रेसिडेंट बता देता हूँ जिनमें हमेशा फुल कोर्ट बनी है। जहां भी इंपॉर्टेंट कॉन्स्टिट्यूशनल क्वेश्चंस अराइज हुए हैं वहां पर फुल कोर्ट बनी है। ये तकरीबन 70 साल की बात है। अब देखिए पहला जो इस किस्म का केस है वो आप सब जानते हैं, फेडरेशन ऑफ पाकिस्तान वर्सेस तमीजुद्दीन खान, PLD 1955 फेडरल कोर्ट 240। It was consisting of full court. At that time, Supreme Court's sanction strength was 5 judges. One incident I'll just point out for the sake of history. One of the learned judges was, however, not available. Justice Shahabuddin. He had been given an assignment as additional governor of East Pakistan. In his place, they completed the quorum of the strength of 5 by taking an ad hoc judge. At that time, the Chief Justice of Lahore High Court, Justice S.A. Rahman. So again, full 5-member bench decided this case. Then, sir, next case, which I'll be referring to, I'll give the list also tomorrow.
Yes, yes.
Jubindra Kishore versus Province of East Pakistan. This was relating to the violations of East Pakistan State Acquisition Tenancy Act. A very important question.
Citation क्या है?
Citation, sir, PLD 1957, Supreme Court 9. By that time, the 56th Constitution had come into existence. It was again full court.
What is the third
The
case?
third case, 8 versus Doso. PLD 1958, Supreme Court 533.
553.
533.
Right?
This
533.
533. At this time, there were only 4 judges of the Supreme Court. One of the judges' vacancy was there. So this was a case heard by 4-member bench. Full court for all intents and purposes. That was the available judges of the Supreme Court. Then next, very important case again, question of interpreting the Constitution, was Fazlul Qadir Chaudhary versus Abdul Haq. PLD 1963. PLD 1963, Supreme Court 486. In this case, a statute was struck down because it was against the Constitution, and at that time it was provided under the Constitution that a minister cannot be a member of the Parliament in a presidential system. But in the garb of resolving the difficulties, the provision of the 62 Constitution, they allowed the ministers to retain their membership of the Parliament. This was struck down by the Supreme Court, by a full court, at that time 5-member Supreme Court. Then, sir, next important case in this regard is Maulana Maududi versus Government of West Pakistan. PLD 1964, Supreme Court 673, in which Supreme Court set aside the notification by the government declaring Jamaat Islami as unlawful association. Again, a case, constitutional case of national importance. Then, sir, next case I'll be referring, Province of East Pakistan versus Sirajul Haq Patwari. PLD 66, Supreme Court 854. Again, all 5-member bench decided relating to the election of certain functionaries under the basic democracies model. So therefore, again a full court. Then the next important case is Asma Jalani versus Government of Punjab. PLD 1972, Supreme Court 139.
एक मिनट रिपीट कर दीजिए प्लीज.
Yes, sir.
रिपीट कर दीजिए PLD.
Yes, 1972, Supreme Court 139.
ये आसमा जिलानी होगी ना.
This was where the martial law and the consequential acts which were performed by General Yahya Khan was declared as illegal, unconstitutional and invalid. The 5 members of the court and all 5 judges sat there. The next important case is the state versus Ziaur Rahman. PLD 1973, Supreme Court 49. Again, 5-member bench, all 5 sat to decide this case. That then next, Begum Nusrat Bhutto versus Chief of Army Staff. PLD 1977, Supreme Court 657. Sir, at that time, the strength of the court was 9 judges, including the Chief Justice. All 9 of them heard and decided this case. And next case is Federation of Pakistan versus Haji Muhammad Saifullah Khan. PLD 1989, Supreme Court 166. At that time, the strength of the Supreme Court was 12 judges, including the Chief Justice. They all heard this case together, and in which it was decided, upheld the judgment of the Lahore High Court, but did not allow the election to take place. They allowed the election to take place and did not restore the government of Mr. Junejo. Then, sir, next important case in this regard is about the dissolution of the assembly headed by Benazir Bhutto Sahib. This is it is Khwaja Ahmad Tariq Rahim versus Federation of Pakistan. PLD 1992 Supreme Court 646. At that time, the strength of the Supreme Court was 12 judges, and all 12 heard this case. Then, sir, next case is Muhammad Nawaz Sharif versus Federation of Pakistan. PLD 1993 Supreme Court 473. At that time, the full court consisted of, or available judges were 11 judges. This decision was taken by all 11 members of the court at that time. Then, sir, this 90s president. Then, sir, Malik Asad Ali's case. Malik Asad Ali versus Federation of Pakistan. PLD 1998 Supreme Court 161. In my humble submission, this is one of the most relevant cases in the context of Pakistan, because there the question was what should whether the appointment of then Chief Justice was valid or not, and therefore all the judges available, because at that time there were 5 or 6 other judges. Chief Justice did not become part of, or was not made part of this bench. And so Justice Ajmal Mia also recused from there. So these 10 judges were the available judges and formed a full court. And that's what they explained. Because they even explained in this judgment that 7 judges could not sit on the bench and had recused, and therefore only 10 members are available as full court. Then next case, Chief Justice Iftihar Muhammad Chaudhry versus President of Pakistan. PLD 2010 Supreme Court 61. Now, this was decided by 13-member full court. Others had recused. Actually, the Chief Justice's case, so he could not sit, and so were some other judges not available. So the available judges were 13 judges. It was formed a full court, and this case was decided by this full court consisting of 13 members. Then, sir, next important case was Bashar Hassan versus Federation of Pakistan. Sindh High Court Bar package. कहाँ पर है? So, sorry, next case which I like to refer to is Sindh High Court Bar Association versus Federation of Pakistan.
Petition बताएं.
Sindh High Court Bar Association versus Federation of Pakistan. PLD 2009 Supreme Court 879 decided by full court of 14 judges. At that time, this may kindly be taken as precedent, there were about 15 other judges who had been appointed under provisional constitution order. So the question was whether they could form part of the bench full court or not. So the answer was that since the very provisional constitution order was under challenge, and those appointed under that, they could not sit under it, and therefore only 14 judges who had not taken oath under PCO were available and was considered as full court and decided the matter. Then sir, next, Mubashir Hassan versus Federation of Pakistan. PLD 2010, Supreme Court 265. This was decided by all 17-member full court, where the Viries of National Reconciliation Ordinance 2007 was struck down, was under question and was struck down. Then sir, next very important case was Nadeem Ahmed versus Federation of Pakistan. In this case, insertion of Article 175A was challenged, and therefore the bench which was formed was of full court. All 17 judges, Chief Justice and all 16 judges sat in this case, where the violations of certain provisions of the 18th Amendment was there. And in that case, what happened was that matter was partly decided and partly sent to the Parliament for adding 2 more judges to the Supreme Court under the Article 175A, and it was done under the 13th Amendment, 19th Amendment. And therefore, citation is, sir, citation is PLD 2010, Supreme Court 1165. The next, again, very important case is that of District Bar Association Rawalpindi versus Federation of Pakistan. PLD 2015, Supreme Court 401. In this case, violations of 18th and 21st constitutional amendments were challenged, and the 17-member by the full court sat on that and ultimately decided the petition against the objection, because it said that since by amendment, 19th Amendment, they have already added 2 judges under Article 175A, therefore that matter is less. So now this is not a question of judicial independence. So therefore that was allowed. And the other matter in this was that of military courts for 2 years, introduced under the 21st Amendment, in which by 11-6 our petition was dismissed. But one thing very remarkable about is that actually the judgment, which is the main judgment on merits, I will be relying on that judgment, because there at least 14 judges out of 17 agreed that these are the basic features of the Constitution.
Salient features की बात की
salient feature की बात की, मगर वो amendment को approve कर दिया plurality judgment के अंदर भी और वैसे भी
वो कर दिया, लेकिन उसमें जहां तक defining the basic features of the Constitution, उस पर 14 judges were,
which includes the independence of judiciary as well.
Independence of judiciary and separation of powers, the democratic system, all that. That was at least by 40 judges.
के against को hold तो नहीं किया उसको उन्होंने जी, basic feature के against hold तो नहीं किया वो 17 judges ने
किया, मैं समझता हूँ किया. उसकी वजह यह है कि उसमें तकरीबन जो 6 dissenting judges थे जो उन्होंने हमारे हक में फैसला किया था, उसमें 5 जज ने तो क्लियरली ये कहा. एक जज ने went into altogether different tangent, Justice Khosa. So they did not consider that. But out of those so-called majority, 8 judges agreed with that there is basic features of the Constitution, and anything against it can be struck down. they made an exception of the 21st Amendment by saying that since it has a sunset clause, that is, the military courts were allowed only for 2 years.
And again
Therefore,
2 years.
they said we are ready to condone it. Otherwise, substantively they said that it should be struck down. Then, sir, next very important case in this regard is
یہ جو سیلنٹ فیچر کی بات ہوئی تھی 17 ججز نے now it will be considered a judgment of 17 members.
this is 17 by
سیلنٹ فیچر کی بات اس میں ہوئی تھی.
جی اس میں
اگر جو میں کہنے والوں کو چکر
جی
اگر کوئی اس سے چھوٹا بینچ ہوگا تو ان سیلنٹ فیچر کو چینج کر سکیں گے یا نہیں کر سکیں گے؟ جو بات 17 نے کہی ہے کیا وہ 13 یا 15 یا 16 کر سکیں گے، یعنی اس کے اگینسٹ جا سکیں گے یا نہیں جا سکیں گے؟
میں نہیں سمجھتا جا
اور اگر اس سے زیادہ ہو تو جا سکتا 17 سے اگر زیادہ ہو.
there has to be یہ 17 سے زیادہ، کیونکہ بے شک 14 نے یہ بات کہی ہے لیکن وہ ججمنٹ تو
17 تھی، وہ 17 کے قصور ہو.
you need more than 17 to do
کیا
that.
خوش نہیں ہوں گے کہ وہ برقرار رہے اور 17 سے چھوٹا بینچ ہو؟
So next judgment I'll be relying on is Justice Qazi Faiz versus President of Pakistan. This is PLD 2021 Supreme Court 1. In this case, there were objections on some of the learned judges. So therefore, the full court was agreed upon, they agreed that there should be full court. Court of 10 judges, because rest of them had either recused themselves. So therefore, only these 10 judges for the available full court, they sat and decided this. Similarly, afterward then, its review petition was heard by again the 10-member bench. This is Justice Qazi Faiz versus President of Pakistan, PLD 2022 Supreme Court 199, in which
دوبارہ بتائیں
جی سر
PLD
199
PLD سپریم کورٹ
and sir
199
سال کے.
sir about reconstitution there is another judgment.
بہتر ہوتا حامد صاحب اب ہمیں یہ لسٹ پرووائڈ کر دیتے
ویسے by tomorrow I'll have this list provided here. جی سر اس میں ایک اسٹیج پر یہ ہوا تھا کانسٹیٹیوشنل بینچ کا پرابلم معاملہ آیا تھا کیونکہ 6 ججز کے سامنے ریویو پٹیشن لگی تھی and we objected to that it has to be heard by 10 judges, a bench of 10 judges at least. In that case, it was decided, yes, the same number of judges will hear the review petition and the same judges. But in the meantime, one of the learned judges who formed the majority in that case, Justice Faisal Arab, I think he had retired, and in his place, Justice Aminuddin Khan was made a member of that bench. So therefore, that was for all intents and purposes a full court that heard. Then Raja Amir versus Federation of Pakistan.
بتا دیں پورے کتنے اور باقی 2 چیز باقی.
Raja Amir versus Federation of Pakistan. The Supreme Court Practice and Procedure Act was.
اس کا سائٹیشن بتا دیجیے.
I'm just going to conclude. 1 or 2 and what?
عامر کا سائٹیشن بتا دیجیے.
جی سر اس کی سائٹیشن ہے PLJ ہے PLJ 2024 Supreme Court 114. So what I'll say, very correctly pointed out by the lady Justice, that formation of full court for hearing important constitutional cases is